Greeting of the day. On behalf of Institute of Law, Nirma University, I welcome you all to this session, which is a part of series of lectures to be delivered in the flagship event of International Teaching Month, which is organized every year by the Institute. The topic of today's session is the Constitution as an anthropological or sociological document. This session is going to be taken by Professor Hakansson. It is my pleasure to introduce Professor Hakansson here. Professor Hakansson is a holder of the Monnet Chair and Professor of Constitutional Law at the University of Piura, Peru, and was a Dean at the School of Law and Director of the Human Rights and Democracy Institute. He is the author of many books which has been published by good publishers. He has written several articles published in the national and international law reviews. It is my gratitude, sir, that you have agreed to be as a part of resource person of this International Teaching Month. Before I hand over the mic to Professor Hakansson, I would like to request to all the participants to keep their camera on and mic on mute mode. Professor Hakansson will speak for 50 minutes and then the question answer session will start. The time has been reserved for question answer session is 10 minutes. You all are requested to kindly send your question to the chat box so that we can take the question from here. With this, now I hand over the mic to Professor Hakansson. Professor Hakansson, welcome you to this International Teaching Month.
Namaste, dear Dean Dr. Madhuri Parikh, Professor Dr. Vikash Kumar Upadhyay, Mrs. Sheila Srivastava, Dr. Irish Powell, see you there, students and participants present here. I'm very grateful to be at Nirma University, my second time, but my first happiness this year. Thank you very much for the opportunity, the new opportunity. This time, I would like to talk about the Constitution like an anthropological and sociological document, a way more humanistic than scientific. The constitutional theory offers different conceptions, like the political organization, one of them, the main factors of powers, the second. Most popular is the supreme law of the land, or a fundamental agreement to protect rights and freedoms. And finally, a constitution to organize or limit the exercise of political power. You know? There are the different conceptions about the constitution, no? The meaning of constitution. Let's go comment on them. The organization of political institutions. This conception came from the European continent in the 18th century. For European jurists like French professor André Oriou, the mission of constitutional law is to organize within the framework of the nation state, no? A peaceful coexistence of power and freedom. No? In brief, it's against sovereignty. No? A constitution is also responsible for the organization, of course. No? A constitution is also responsible for the organization. No? The structure of a political community, main institutions, and intrinsic relationships needs the organization, but its origin was not organized. Historically, it was warned against the postulates of the states, no? The sovereignty. This purpose is not characteristic of the constitutional, because throughout history, the different political communities have needed to organize their institutions. Simple like that. Indeed, the polis in ancient Greece and a Hobbesian theory had orders even contrary to the principles of the constitutionalism. No? In this sense, the organization is also implicit in the internal structure of a modern constitution. No? That's my point of view. The second, the expression of the natural factor of powers. No? This meaning, born during a famous speech in Berlin, no? Finished the 19th century. Ferdinand Lassalle, no? Ferdinand Lassalle in Berlin argued that this was enough to place the factor of powers on a sheet of paper, no? If one of you put the factor of powers, no, write the factor of power on a sheet of paper, then a constitution is there, no. That's a Lassalle, no. It's a concept closer to political science, I think, no? Because it revolves around powers, no. The political science revolves around the power, no? Different from constitutional law, no? That does it to freedom, no? The core of the constitutional theory is freedom, not power. Constitutional theory wants to control the power, no? The constitutionalist idea is before the codification also, no? The British Carta Magna was far from describing institutions to recognizing rights and freedoms. The Constitution established the competencies of each function of power. No, that's the third meaning is famous, no, in the Anglo-Saxon countries. The supreme law of a legal system, no? The supreme law of a legal system. The European judicial practice endorsed the normative value of the Constitution. The legal system is that codification for systematizing the functioning of society as a whole, no? Hans Kelsen was the first to say about a constitution like the best or the most important norm for a country, no? Hans Kelsen, Pure Theory Law, no? His principal book, is a conception that became the most successful of all European and Latin American continents, no? Kelsen needed to protect the legal system in a superior norm, no? That no one could contradict, and that all articles with content precisely because of it, no, is the most important norm in a country, in a state, no. The Constitution is the way to give validity, no, support, and presides over the set of norms of a closed legal system, no, with a certain openness to international law and without black holes, no, black holes. This conception is the most widespread and perhaps has made it possible for countries, especially Latin American countries, without a democratic tradition, no, to measure the success of their constitution, no? Without Hans Kelsen theory, maybe Latin American countries hasn't a constitution, no? Kelsen reduced, no, the concept of constitution like only the best of supreme law in a country. That's right, but it's not the principal objective target, no, of the constitutional theory, no. We consider that it suffers from a reductionist vision about the content of the written constitution. It always had a dual nature, no? Each constitution has a dual nature. Political, first, no, because it seeks to limit power, and legal because it does it by the law, no? Needs both nature. All constitutionality cannot contain in a text code. It's impossible, no? The principles of jurisprudence tradition are part of a block of constitutionality, no? On the other hand, the Constitution was born in countries like the United Kingdom and North America, no? It is open and not closed, no? unlike the countries closest to the continental European tradition. No? The judges on the United States or United Kingdom interpret the Constitution. The Constitution is open, no? Not closed. No? The jurisprudence open the Constitution, no? The interpretation, no? Not closed. Meaning the fourth meaning is a consequence of a consequence of fundamental political, historical, and cultural agreement. No? The Constitution is a pact of limit to the power to ensure a sphere of rights and freedoms to the citizen, to the all citizen. No? It is the definition that we subscribe, no, to, and that is in line with a classic vision of constitutional theory, which includes the thought of Karl Levenstein, Friedrich, and Martin Grille. No? Considering its historical origin, the Constitution is, let's repeat it, a means to limit the power of the rulers that ensures a sphere of rights and freedoms to the citizens. No? The idea of organizing political institutions reduces the scope of the unconstitutional rules contrary to the provision of the Carta Magna, no? Seeing in parallel the law and the covenant. The Constitution must result from a fundamental agreement. It's a fundamental agreement. No? All thought it's enveloped in an act. No? The idea of a constitution as an alliance receives better and more conveniently the thesis that there are no internal contradictions in the constitution. No? We need to interpret it with unity. No? A conception that promotes the idea that there are not conflict of rights is closer to a Christian doctrine of the human person, of the citizen freedoms. No? In other words, the Constitution is created to protect citizens, not to present or assault the state. No? Not the Constitution from the state. No? Is for the citizens. No? The Anglo-Saxon mentality, I would like to talk about the Anglo-Saxon mentality versus the European continental conception of constitution. No? The constitution is closer to being a fundamental agreement, no? I said. Indeed, today, every state, whatever its political regimen, formally has a Carta Magna, no? Even Venezuela, Bolivia, Cuba, China, formally has a Carta Magna, no? Regardless of its purpose to limit the exercise of power. Therefore, the countries with a continental European mentality are more flexible to change than those with an Anglo-Saxon mentality, no? Because they are more conservative. No? In other words, while the Anglo-Saxon take care of the substance to put in the means to make a constitution work, the countries with a continental European mentality, especially the Latin American ones, are concerned with the form. No? I have a written constitution, that's all. No? I declare that it is the most important norm in my country, that's all. Is the constitution of my states, no? Wrong. Is the constitution of the citizen. This matter will be applied in a different historical, political, and cultural reality. No? For example, no, one of the Jane Austen novels, no, Manfred Park, for example, draws attention to the literary appreciation of Lord Crawford, one of the for the characters, no? When he argues that anyone does get acquainted with Shakespeare reading him. No? He affirms that it's his part of the English Constitution. No? Lord Crawford, and the novel, Manfred Part says, of affirms, no? that Shakespeare has part of the English Constitution. No? It's amazing. No? The English literature has essential reference about the sense and sensibility, of a constitution. On Dickens, our mutual friend, the dialogue of Mr. Posnap and the foreign gentleman show as a sociological vision. No? Mr. Posnap says something like this, no? We Englishmen are very proud of our constitution. So it was bestowed upon us by Providence. No other country is so favored as this country. Another country, said the foreign gentleman, they do how? Mr. Posnap answered, they do, I'm sorry to be obligated to say it, as they do, as they do. No? It's that constitutional theory is we see it inside the culture, no, of the English people, no, the English people, the Anglo-Saxon, no. What about the so-called modern constitution? No? It's finished the Second World War. I would like to talk about the called modern constitutions. What constitution must contain to be considered modern? It's my first question. No? In continental Europe, towards the end of the Second World War, I said, a revisionist trend began around the content of constitutional text. No, begin some change. No, in European continent. No, finished the Second World War. No? The constitution of late 1940s to the 1970s began to emphasize declaration of rights. No? Some of them starting with recognized human dignity, no? Like Poland, then Germany, no? The first one, Spain also, no? A trend that in parallel, the international community also endorsed with the Universal Declaration of Human Rights, international covenants, no? Etc. No? From the institutional point of view, they blamed the parliament for causing periods of political instability, no? Especially in parliamentary models. They can copy the British Constitution. It's impossible. No? The British Constitution contains not only norms, no? It's unwritten, no? Contain many conventions, traditions, no? Part of history, no? It's an old building, no? Edificated in a long time, but it's impossible to copy norms or copy traditions and put it in a written constitution. No, that's the error, the mistake, no, of European constitutions and Latin American constitutions. No, the international community, I repeat it, also endorsed it with the Universal Declaration of Human Rights, international covenants, etc. No? From an institutional point of view, they blamed parliament for causing period of political instability, they said, no? Especially in parliamentary models. No? Therefore, it was necessary to rationalize it. The best way to achieve this was by blocking or putting up barriers for exercising its instrument of parliamentary control, no? Like, for example, the vote of no confidence, no? In Spain, in Germany, create the constructive vote of confidence. No, I can put down a prime minister if the opposition doesn't have his other new prime minister to take place. No, take place. But there were other changes. No, I see. The institution of direct democracy that coexists in a system that is represented by definition. No, the referendums, for example, no, use the referendums. No, in addition of other characteristics that have given rise to a model of constitution that has found a space, and its main elements are the following. No? First of all, modern constitution has declared itself as the highest standard legal system. No? That's the first characteristic. No? Second, generous catalogs of rights, including social and even duties. No? Third, specialized constitutional courts. No? Constitutional courts. No? The massive creation of constitutional guarantees. No? 6 or more. No? Fifth, supranational protection of human rights. The institution of the ombudsman is a Swedish institution, copied it by many countries. The elements of the neo-presidentialism, no, ahead of the executive with competence to legislate, president of a republic to competence to legislate, dissolve the parliament, file constitutional action, propose reforms, etc. No, some are modern competence of the presidential leader, no, in Latin America countries, no, like Peru, my country. We observe that most classic constitutions have not needed such instruments. No? Is the main difference. No, the longevity of their institution in Britain and in the States still works well for a full recognition of rights and political stability. No, as we mentioned it, the Latin Americans' written constitution, no, is the difference. No, permanent conflicts, instability, coup d'etat, no, like Nicaragua, Venezuela, Bolivia, Peru, no, Ecuador, no, are many examples. Now Argentina, no, has an authoritarian government, doesn't observe the constitution. No, I think that the continental Europe, the European Europe constitutions only spread the ideas of constitutionalism, no, to the world, no, like French, no, the first country to share, no, the constitutionalist idea, no, after the revolution on 19th century to America, to South America, no. Napoleon in Europe and Bolivar, no, and Simon Bolivar in Latin America, no? Colombia, Ecuador, Peru, is Venezuela, no? Region. San Martin, General San Martin on Argentina, Chile, no? Uruguay. The second half of 20th century changes the content of constitution, no? That emerged yet from the time of would have to call modern, no? Modern, no? The ombudsman, no, is the ombudsman is a Sweden institution, in English, like the defender of citizens, will emerge, no, new institution for control to a public administration in the constitutional courts, no. However, this statement might not be so exact, because many of these institutions would rather be instrument of the judgment to alleviate certain deficiencies in the functioning of contemporary constitution. No? The classic constitution doesn't need ombudsman. No? The United States has an ombudsman. No? Classical constitutionalism needs to create an apartment, new institution that will have another natural purpose, no, to support it, because the classic one doesn't work. No. What about the origin of constitutional form of government? The classic form of government, like presidentialism, parliamentarism, the first, like the original parliamentarism and presidentialist systems, no, were born in Anglo-Saxon countries, no. Parliamentarism born in UK, no, and presidentialism born in the States, no. The first in United Kingdom, parliamentarism, and the second in the United States of America, presidentialism, no. European constitution propose institution of both forms of government, no. Maybe a model called French semi-presidential, no? In 1958, no, constitution, no, the last French constitution. The president in French is elected by direct universal suffrage, but needs to cohabit with opposition leader when he loses a majority in the National Assembly, no? Now that is changed, you know. In French, made some reforms to edit the possibility to French president needs to need a prime minister from the opposition. You know? It's, the newspaper, the journalist of the Le Monde newspaper in French denominate this situation like a cohabitation, no? Call that political relationship like cohabitation. Now, in French constitution, the parliament made some reforms, and the last time of cohabitation was on 1997. 1997. The first was the Mitterrand Chirac, 1986. The second with Mitterrand Balladur, and the last one in 1997, Chirac with Jospin. No? With Jospin. No? Now Sarkozy, Macron doesn't problems. No, don't need the cohabitation. Concerning Latin American presidentialism, we observed more than one difference between the classic and original American model. No? A different history and circumstances, a different mentality also, and a legal tradition led these countries to take only those institutions that could adapt to their social and political reality. No? The first problem is the constituents' motivation to choose this form of government at the beginning of the century. No? The postulates of the French Revolution inspired the liberty of the Spanish colonies, no, in America. However, they opted for the presidential form of government, no? Like the United States, no? Which was a form of government created for a republic and the presidential model serving the political needs of the leaders of the emancipatory movement, you know, like Bolivar or San Martin. No? San Martin thinks to Peru, for example, that we need more monarchy temporarily, no, than a republic, no, because he observed our reality, no, social and cultural reality, no. Peru was the center, the core of the Virreinato, and the forms and relationship for the people. Maybe San Martin was right, no, but the French Constitution inspired many political leaders here, and we chose to the presidentialists, no, like today, no. The presidential experience in the United States has a different development compared to Latin America, no. If American presidentialism is an original model, its first colonies were the classic English constitutional tradition, no? Hereded. No? The features in the presidential model and in Ibero-America, Latin America, such a separate election for the executive and legislative. No? In Peru, for example, executive and legislative, we elected the executive and legislative at the first time. No? But the logical of a presidentialist model is elect the executive and legislative in different selection process of democratic process. No? I think that modern constitution is only continental European concept. No? When we talk about modern constitutionalism, it's only about a constitutional European point of view. No? A constitution experience be in European or Latin American continent when the constitutional institution implement the separation of power and the rule of law as occurs in Anglo-Saxon constitutions that, despite their years, still function and are in good shape. No? In other words, a new body or institution will be useless for the defense and protection of fundamental rights. Is there no separation of power, horizontal and vertical in practice? No? For example, the federalism is like a view of the separation of power with a vertical view, no? Vertical view, federalism. No? Otherwise, the executive could invite other powers and 13 freedom, like that tentacle of an octopus when it fishes its prey. No? In other words, constitutions are not better because they are more advanced, but because of their effective limitation of power. That's the point, that's the target. No? When the constitution can be the instrument to effective limitation to power. There's no other main reason. The main reason is effective limitation of power. An example is the written North American Constitution, again, over 200 years old than the Latin American written Constitution, now written by a computer and inspired by the most influential European constitution, whose actual validity is usually limited. No? Latin American Constitution changed their written constitution many times. No? Now, when you know that Chile has a new constitutional convention to change his constitutional order. No? Now we have a debate about that. No? Here in Peru, President Castillo wants to convocate a new assembly to change our constitution. No? It's a miracle to us that he, until now, he can't convocate that assembly. No, we fight with citizens, we fight with them. Many citizens fight with them in the streets. No, against the possibility to a new constitutional assembly. Therefore, we could conclude that the main contribution of constitutionalism ended in the 18th century. No? The main contribution of the constitutionalism ended in the 18th century. No? That's my position. No? or the beginning of the 19th, no? For those who consider the Marbury versus Madison first leading case, no? About the judicial review, no? Create the judicial review, Judge Marshall, and not the previous antecedent that belonged to the last century, no? If maybe the last constitutional institution born in the first beginning the 19th century, no? With the Marbury versus Madison leading case and create the judicial review, no? Judge Marshall. No? It can also conclude that the so-called modern constitutionalism is continental European, no? And has not affected the countries with a constitutional tradition, no? Especially the Anglo-Saxon ones. No? The constitutionalism is the consequence of a Anglo-Saxon culture and judiciary common law, no? The judiciary, the common law and the common law. Rest of countries like European, Latin America, copy institution, but with different results. No? Constitution, culture, common sense work with each other. No? The telling about men forced to work in the galleys on the novel The Ingenious Gentleman Don Quixote of the Mancha novel. When Don Quixote, after hearing and questioning the reasons for the arrest, Don Quixote decides, no? A mark of prudence not do by foul means what may be done by fair. I will ask this gentleman, the wards and commissary, to be so good as to release you and let you go in peace, as there will be no lack of order to serve the king under more favorable circumstances. Others who serve the king on better occasion will be lacking, because it seems hard to do slaves that God and nature made free, said Don Quixote. Finally, Don Quixote became the judge, no? I think, who knows habeas corpus, no? In applying a monarch's disposition to oppose higher values, like liberty, like freedom. Today, we find the provisions constitutional as an anthropological or sociological document. Finally, my conclusion. No? A written constitution establishes, distributes, and limits power and provides mechanisms for deliberating and deciding on public policies. Precisely, the constitutional theory was a result of many factors, such as philosophical tradition on human person, and reflect a broad consensus about life, dignity, freedom, equality, and property. The common law vision about against civil law, one defends a supreme law vision through the positivist doctrine. It is possible to identify two constitutions with different but complementary purposes. No? First, an anthropological text represents the coming together of people of diverse ethnic groups, ideologies, regions, culture, religions, who are united in their diversity by a shared civic vision. Second, a sociological test rests only upon pragmatic and procedural agreements, which negotiate to provide the society a basis of peace and stability in a given territory, with only weak and conditional sense of shared, identified, or common purposes. My speech wants to compare traditional and modern constitution, looking for answer and explore the difference between a fundamental agreement, an act of faith, like UK and USA, with only a pragmatic and procedural document, legislative technique, I think, like German, Spain, for example, and the rest on Latin American countries. Thank you very much. Namaste.
Thank you, Professor Hankinson. It was really very, thought-provoking kind of session where people had got a kind of lot of questions in their mind, and they had shared with me as well so many questions. So on this session, I
Was
have
an
one.
honor.
I have one question from my faculty, Sukrit sir. He has a question that we find constitution to be drafted for and then made to function in a definite sociological setting. We also found constitution, at least since World War II, attempting to keep some values, decisions away from the people or for their representatives through the internity clause, Germany, and basic structure doctrine in India. How have the Latin American constitutions responded to this felt need to secure some values from being disturbed by further action?
Well, I think that European countries and maybe Asian countries has some difficulties and has difficulties to get the inspire and the tradition that origin the real constitution in the world. When I talk with a professor of Oxford, they say me that the first document, constitutional document, they remember is the Carta Magna, but is the development of the constitutional institution grow up, grow up in many years, decades. Is too difficult to European constitutions to get, to catch. The positivists use it to copy institution, but about the function, in the practice, has problems to get better results. Maybe I think that Europe has a fundamental procedure, but Anglo-Saxon countries has things like a constitution is the best agreement, to live in freedom and in democracy, and a special country is I think is Israel. Israel has an unwritten constitution. First one is UK. The second is Israel. Israel has an unwritten constitution, but it's a mixture of positive. It's a mixture with law. It's a mixture of religion. It has some and Germany is a special cases. The first one is the United Kingdom. Germany is has a best tribunal, best constitutional court. I recognize that, but the past of Germany is not democratic. Germany write his democratic history since this constitution of 1949, but years ago Germany hasn't a democratic tradition. It's new, and since German constitution 1949, I think, Spain has the best constitution in Spain is just the 1978 constitution, the last constitution. The last constitution in Spain made the democratic transition. No? Now, some regions, no, like Catalonia, no, or País Vasco, fight against that constitution, but I conclude that it's the best constitution in Spain. It's the written constitution most close to an agreement, no? But now they are in crisis. No, the monarchy is in some crisis. Then in Spain, no? The monarchy and United Kingdom is a rock. No, it's a rock. Principe Andres has problems, but the monarchy is a rock. No, then in United Kingdom. I think that constitutional theory, no, the constitutionalisms are supported by two causes. No, first the common law, no, and second one and longest tradition, history tradition. No, since the Carta Magna, no? Since the Carta Magna, no? In the third century, no? I think that maybe I can respond some aspect, maybe I can hear it, but it's half of the question. For me, excellent. Thank you.
Sir, we have another question from our faculty, Dr. Hutta sir. He has asked a question to you that how do you evaluate the Constitution as an act of faith from indigenous perspective in your own country or pan-Latin America?
How I think about the Constitution, like agreement, act of faith in, please repeat me, please, sorry.
As an act of faith from indigenous perspective in your own country or pan-Latin America?
It's difficult to say. No, in Latin America has many written constitutions. No, my country has 12 constitutions in their history. Chile is writing a new constitution. Ecuador on 2007. No. Venezuela 2000, Bolivia 2009. I think it's the problem. I think is like the position of Bernard Crick. No? It's a Scotland professor, who was a Scotland professor, that say that not all the countries has the position, no, to make really politics, no, great politics, no. That's the question, no. Politics is a human activity, no, to get the common good, no, common good to all the citizens. But maybe this is that's the key of the problem, that Latin America, also, no, European countries forget, no, that politics, real politics, is the way to make best constitutional institutions, no, like an instrument to do again, no, good politics, no. In my country, for example, first my country, executive and legislative fight against each other all time, but in other countries, the executive and legislative fight about different positions, no, about a new act a new act to regulate the labor relationship with the workers and the owners. No, is for me is that is the politics. No, that is the politics. No, let's fight for fight. It's fight to get more good common good. No, is that not function? The constitutional theory not the is not it would not get them act of faith. No, it's an act of faith because I am sure that if I do the correct things, no, while I limit the power, I guarantee freedoms and live in a democratic society. No? It's but things about legislative procedure is not strong, that position, no? And the constitutions, written constitutions, maybe are formal documents, but not a real way to get freedom while control the power exercise. No, is I think is the best grade. No, to think that a country has a constitution is when the people knows that the power is controlled. No, it's controlled, and with the power is controlled, we have freedom. Today, no, in COVID moments, no, the people who against the people who fight with more liberties is the people, or the people against the COVID passport, no, is fight for his liberties, no, his own liberties, no, responsible. That's maybe it's polemic that I say, but I think that this example, no, to know, no, where countries has inside here the freedom, the idea of freedom or liberty of politics. No, I think I know it's polemic, but I like to share, no, these ideas with you. Thank you.
Sir, there is another question that what is the universal characteristic of constitution? Is there some universal things which we may find that in each constitution we can have this kind of the characteristics in all the constitution? Is there some universality in the constitution, or every constitution are being governed as per their own conditions or society? Can we identify some universal aspects in the constitution?
See, thank you. I be very happy with all the questions. Thank you. The principal parts of the Constitution, the classic Constitution, is already as the recognized freedoms, liberties, separation of powers, best principles about the rule of law, and mechanisms to reform the Constitution. There are only four. But Latin American, but European Constitution or Latin American Constitution have others, no? Others elements, no? A special constitutional court outside the judiciary. No? The ombudsman was the defender of the citizens, no? In using English expression, no? To translate the meaning of ombudsman, no? It's a Sweden concept. then has a chapter dedicated the economic constitution, no? My country has a special chapter of, they say, the economic constitution, no? With some principles to take quiet, no? The state, no? And not be or this, limit the state to be a CEO, no, or like a owner of public enterprises. No, it's just that the economic is a subsidiary. The state only make economic action if the privates doesn't do it. The state needs to make actions, no, in the economy, no, is the only way. The constitutions written on finished the 20th century has a economic chapter of the economic constitution, no? But classic constitutions, like in the United States, for example, United States, no, the first economic country, the first economy in the world, the states doesn't have a chapter because the economic freedoms, we know the economic freedoms inside the classic rights of liberties, no? But we need in our countries like Spain also a special chapter to express, no, the principle of economy, no, and the limit of the states in the economy is other, no. There are many other institution. Modern institution is assembly to special assembly to elect the judges. No, it's so polemical. It's so a polemical institution. No? The best constitutional countries has only 4 great institutions, 2 works, no? Executive, legislative, judiciary, rule of law, and 5, the a procedure to reform the constitution, no? A procedure to reform the constitution. European country, Latin American has other, no? Why? Because the principle, the main institution doesn't work, and needs other institution to support that, to support the others, no? To support the others, no? That's the best difference between the classic constitution than the Latin American or some European constitutions. No? The best constitution in Europe is maybe Germany, because it's since the last constitution, no? 1949, German begins his democratic way, no? Since this constitution. No? Thank you very much.
Sir, there is one question from the students. She's asking a question that whether the federal characteristics of the federal constitution is helping us to have a sociological document, or the constitution can be made as per the society or like that in a federal constitution. How the federal constitution is helping to have a anthropological or sociological constitution?
Well, when the constitutions, the written constitutions has the human person in the core, has the human person in the center, writing the founding fathers of any constitution put the person in the center, when that's a great begin, no? It's a great begin to know, no, what's the way, no? When uh, when others countries like put in the center the state, the government, no, the second constitution of the of Peruvian state, for me wrong, no, constitution to the Peruvian citizens. Peruvian citizens is the first step, no, to know that something is clear, no, in that country, no. The constitution borns against the state, no. The origin of the constitution born against the state, no. The constitution put limits at the government, no, the states and the political institutions, no, to guarantee rights and liberties, no. We need to look that, no, and European constitutions and Latin American, that's for French, no, maybe since Napoleon, no, the concept, no, of the state, no, the state, the strong, the state, no, and forget the real idea of the constitutionalist theory, no. United Kingdom had the Glory Revolution, no, on 17th century, no, and that makes and that consolidated his constitutional institutions, no, that make the constitutional monarchy, no, monarchy. And in the United States, the Glory Revolutions fight against the sovereignty, no. King Estuardo wants to copy, no, French style of government, no? Then they get a revolution, no? It's Oliver Cromwell. And in Europe, the state is the theory of the strong state born, no, in the modern age against the conflict with the religions, no? And they need the state to get peace, but against the liberties, no? That's the main difference without the origin of the natural origin and development of the constitutionalism in Anglo-Saxon countries than in Latin America. Latin America and in Europe, the constitutionalism is a combination with the positivist theory and the codification, no? Positive codification, positive theory of law, and that constitutionalism, no? Europe thinks about the Rechtsstaat, no, the Rechtsstaat, that's a German conception, but in Anglo-Saxon countries, things about the rule of law, rule of law, rule of law. If I say rule of law in my country, maybe many people answer me, I don't know what you say, no? That is Rechtsstaat is a German contribution, no? The régime administratif in French, but those are theories that live in Europe, but they are very contradictory, no? Very contradictory, I think. And that was one of the causes that I think that Latin America and Europe constitutions have the similar problems, no? Similar problems. Thank you.
Sir, this is the last question. The student has asked a question. He has asked a question that if we look at the independent declaration of Israel, we find that they have made this constitution or like that declaration only for the people of Jews. So when they are making this kind of the declaration, do you not think that it would be a kind of, we are going more for ethnicity, or like that we are going to divide on more ethnicity basis, and it would be a nation like ethno-nationalism would be more going into the demand in future as well?
Well, I think that the Declaration of Human Rights, the Universal Declaration of Human Rights, and the other international instrument to recognize freedoms and liberties are excellent, no? But I think that when the person is not the center, the core of that instrument, maybe the singular person is not in the core of the centuries, maybe we make a problem, no? Because now we create the rights of the groups, of different groups, singular groups, no? Otherwise, the rights of the animals is heresy. I'm not support that affirmations. No? I respect the religions. I respect any religions. No, it's tolerate. It's democratic. It's excellent. But I think that the law is created put the person in the center, no, not the group, no, the person. Maybe the international public law shared to the world that there is other point of view about human rights, put the group about, for example, about rights of the children, rights of the women. It's true, but children and women are human person, no? And human person. When we talk about freedom, about rights and liberties, are the same to any kind of man or of any kind of person, no? Same, say, woman, man, children, no? It's the same. But when international assemblies create, no, treaties about only talking about children, maybe the point of view is not correct. No, I think that the important that the children and women or old persons, no, has the same rights like any person in the world. Then good news is the international public law by treaties create international courts, no? But in other countries, for example, is the United States, no, is the second capital of the Constitution is against international courts, no, because they think that they create his Supreme Court, and that's all, no, not recognize other international courts around the world, no? The Penal International Court, for example, no? Or la Corte Interamericana de Derechos Humanos, no? In Costa Rica. It's not I think it's important, no? It's the Declaration of Rights, the treaties, but it's important also not forget that the person is the target, the core, no? The center of the law, When if we forget that, we have a problem, no? We have a great problem. No? And that is a machine to make mistakes, no? It's, I think. Thank you for your question.
Thank you, Professor Hakansson. This thought-provoking session was really, I think it will motivate us to do more research and reading in this perspective, that how the Constitution develops and how the anthropological aspects are there in the Constitution. So it will motivate us and others also that how to do a kind of comparative study. So it was really a very nice and thought-provoking session, sir.
Thank you very much for the invitation. It's my first happiness this year to stay with you. As Dr. Mahuri, thank you very much. It's an honor to me to be here. I'm feels here in India, in Nirma University. Shreya, thank you again. Vikash, thank you for everything that to translate the questions. And I hope to see you next time. No, for me it's an honor, and so happy to stay here today. Thank you to the students, all the students. No, great questions. Great questions, students. Thank you very much.
Thank you so much. Thank you so much.
Next, see you next time, I hope.
Yes, of course. Yes.
Thank you so much, Professor Hakansson. Have a good day.
Thank you, Shreya. Maybe I can your second name maybe has this Srivastava. Srivastava.
Yes.
Next time I do I will do best.
Shreya is just fine.
Thank you.
Thank you, Professor.
Thank you.
Thank you.
Thank you. Bye-bye.